All right, well maybe sometimes when I start talking, I run away, leave the room. So maybe if I start talking now, people actually coming in because they'll know that we have some, we're starting. So, and closing the door is a good one too. So it was kind of funny as I was driving in here. It seemed like just yesterday I graduated from the law school, but it's going on 2 decades, and how fast your career starts moving once you get out of law school is really an incredible thing, and it drives home the point when you come back to the law school you graduated from it. As I was walking in, I remembered the word, my corporations professor, Professor Henning, is still here, and he's seen in the newspaper, quoted all the time. Excellent professor. And he would stand up at the podium and in the loudest voices, probably to wake everyone up, talk about Justice Cardozo and the punctilio of the honor of the most sensitive, and the workaday world, and how there's this fiduciary concept that requires people to act better than they would in the workaday world, implying that the workaday world is a very rough place. So it's those fiduciary concepts which underlie the shareholder and member oppression statutes as they've come to be known. And with the proliferation of the business courts and Supreme Court precedents on these issues, we thought that it would be a good idea to hold one of the business law section's forums on this concept. And we ran it in Grand Rapids last week, and we're running it this week, tonight, here in Detroit. And in order to make it sound really important, we call it a symposium. And this is and so thank you very much for coming down here through the rain for the symposium on corporate oppression issues. And before we get going, I'd like to give special thanks to some people at the law school who made this possible tonight. The Wayne Laws Entrepreneurship and Business Law Society and the Wayne State University Journal of Business Law co-sponsored this program and helped us secure the law school. That's a place where we can do this, and to hopefully generate some interest in the student body with respect to the body of law that's developing rapidly and becoming raising some very interesting issues for us to talk about. In addition, the Wayne Law Career Services, and especially Cindy Hilbreath and Tish Browning, who helped make this possible tonight. So the oppression statute is an interesting one, and it hasn't always been easy to apply, either for the judiciary or for the practitioners. If you go back to the early days of the statute, there was even a case that held no direct cause of action exists under this statute. In the Box case, anybody who practices in this area knows that case well. And it was a terrible holding. No offense if anybody worked on that case. I know one of my friends, Joel Newman, takes credit for that case. And I point out that it was correctly reversed in Estes, and then the Box holding decision on whether the statute was a statute of limitation or a statute of repose was reversed more recently by the Supreme Court in another case. And we even had a question for years whether it was a jury or a judge who decided how this statute would be applied and the remedies that would be imposed. And it was only a couple of years ago in the Matagula case, the Supreme Court said, you get a jury trial, they struck the jury trial and said it's a judge trial. It's a bench trial across the board in the statute. It's also an interesting statute in the sense that we have a Supreme Court decision holding that a claim accrues when there's no calculable financial injury. And that's creating for some interesting arguments at the trial court level right now, and also at the appellate level in the Castle versus Shohan case that is recently issued some important decisions on the concepts of fairness in interested transactions, and when the termination of employment of a shareholder constitutes oppression. and whether capital calls can be done by consent or without votes, and interested transactions can occur in that manner also. And that case is, there's applications pending to the Supreme Court in that case. And so a lot of these issues will, it's possible they will be tested, because there's at least two issues that I feel have a strong chance of going up to the Supreme Court. And in fact, I got to file a brief on one of them on Monday, so we're going to move it along. We have some great speakers here tonight. Powell Miller, David Hansma, Tom Frazee, Frank Simon, and the Honorable Lita Popke. And we're going to try and move things along so that we can have plenty of time at the end for some question and answer and open conversation with Judge Popke. And in order to facilitate that, some of the law students will be handing out note cards that you can write some questions on, and they'll be picked up later on in the presentation. And that way we can start the conversation that way. And but feel free. I've spoken with all the speakers, and if anybody has a comment or totally disagrees with something that somebody's saying, feel free to chime in, or if you're bold enough, you can come on up and go toe-to-toe. But I'll get out of here before you do that. So the first speaker tonight is Powell Honus Miller, and we all know about his baseball card collection, and in particular Honus Wagner, and I've worked for Powell and with Powell. Unfortunately, I haven't been against him yet, but you know, they call him Honus because he has his baseball cards, and he also hits it out of the park in the courtroom. He's here hot on the heels of a 15-day arbitration in Chicago, where I'm sure that the result will be similar, if not the same, to all of his other trials and arbitrations. So the undefeated Powell Miller, if you'd like to come up here and maybe turn to the mic.
Thank you very much, Mark. It's really exciting to see how you've grown in your career. Mark started with me, and he's unquestionably become one of the top lawyers in our state. And he really did laboring war for the outline on the material that I will discuss because of my recent arbitration. It's a good thing this is only 20 minutes, because if I talk for more than 20 minutes, that would be a perfect example of oppression. And I don't want to cause any depression here either. So I'd like to kind of, mostly I'm going to go off script and try to give you some practical insights into being a plaintiff's attorney in the area of shareholder oppression. I will go through some of the prepared materials, but you will have those materials and will be available to all of you. And I think they do a very good job of hitting the high points of shareholder oppression law, other causes of action that you might want to think about. Now, in my career, I've had always some oppression cases in the office. I can't think of one time where we weren't prosecuting at least one shareholder oppression case, and often more than one case. But a lot of them have involved, sadly, family members. So I'd like to start with family members as a hypothetical, because it's a very common situation that sadly can result in litigation, and sometimes the worst litigation. So a hypothetical is there are 5 kids, young adults, whose parents built a company, ABC Company, and the parents died 4 or 5 years ago. 4 of the kids had no interest in running the business at all, just Brother Joe. And Brother Joe takes the reins of the business, and all own 20%. So one way I approach, so one of the siblings comes into the office to see you, and they want advice. What does it mean that I'm a 20% shareholder? You know, I've gotten the same checks now for 3-4 years. And Brother Joe, he's built a 12,000 square foot house now. He's got a nice silver Ferrari. Is something wrong here? Well, I always keep in mind one of my favorite books I read in high school, George Orwell's Animal Farm. all animals are equal, but some animals are more equal than others. I can assure you that in this hypothetical, Joe is not an equal animal. and the sibling who came into your office had a very good reason to wonder, how come my dividend checks have been the same every year, but all of a sudden my brother seems to have enjoyed extraordinary new wealth. So what do you do in that situation? In a family situation, my first priority is to see if I can save the family. Because I have found they go one of two ways. If you intervene quickly, you got a chance of settling it very quickly and keeping a family together. There's no better feeling than that. You get plenty of cases and plenty of opportunities to make a lot of money. If it's a family situation, I try especially hard to see if it can be worked out. And I found that about half the time it can, because there's a familial bond there. So I'll frequently try to get an early mediation or an early facilitation, really to see if there's a way to resolve it, even before any kind of litigation has to be filed. The next thing that should come to mind immediately is statute of limitations. Always think about how much time do I have, particularly in oppression cases. When there's oppression, it's just like the old cookie jar scenario. It usually starts with taking one little cookie, then a second cookie, and then they start taking them by the handfuls. And this can go on for many, many years. So the longer you wait, the greater the risk that a portion of your case is going to disappear every single day. So I always assess the statute of limitations early on, explain that to my client so they understand, because there's, especially in a family, on the one hand you want to see if you can resolve it quickly. On the other hand, there's a significant, very, very significant risk that you can't, and the clock is ticking. So you want to think about a tolling agreement to protect you and your client from the clock running out. The other thing that I found, as now a practitioner for many years, is there's tension in our law. The statute of limitations interpretations are getting tougher. They're becoming more pro-defense all the time, which means the more time you take, the greater the risk you have that you're going to lose some or all of your claims. On the other hand, courts are becoming more exacting about the amount of detail you have in your complaint. And the more detail that you have in your complaint, the more likely that you will survive an initial motion to dismiss, and you'll get a fair chance at discovery. That's an inherent tension that now exists in our law and has to be thought through very, very carefully. So I suspect right away this is an easy one with the Ferrari and the 12,000 square foot home, that there's a high probability that oppression exists. In fact, I believe that a very small percentage of oppression in closely held companies in Michigan is ever detected. I think there's a lot of it out there that just goes by the wayside, and people don't either understand that they're a victim of it, or they choose to look the other way. So shareholder oppression is very, very common. So what options do you have? And you have a shareholder oppression remedy. And that was what comes to mind first. In a minute, I'll talk about some more remedies that you have. But you also want to make sure that you get the key documents quickly, especially because of statute of limitations. on the initial call, even before the client comes in, I ask them, please get me all your paperwork that you have. Do you have an operating agreement? Do you have a shareholder agreement? Do you have articles of incorporation? Do you have bylaws? The sooner you can get and assess the key corporate documents and contracts, the farther along on the learning curve that you will be, and you'll be in a much better situation to exercise judgment about whether there's a case there, whether it's something you need to get on file sooner rather than later, or whether you have time to really work it up. And sometimes what you can do is you suspect oppression, but a lot of times, particularly in these families, the sibling that comes to you doesn't have a clue. They were never interested in the business. They don't really understand what's going on in the business. So a really good thing to do is to start asking questions in writing. And let's find out what Brother Joe has to say. Because a lot of times, if you frame the questions the right way, based upon the answers that you get from Joe, will create liability for Joe and give you an opportunity to bring an effective case. So, the Shareholder Oppression Statute 450.1489 is very powerful in Michigan. In fact, it's become so powerful that I'd say about 1/3 of the cases that we get in the door now that look like, at first, they're good shareholder oppression cases, the parties choose to apply Delaware law because they want to try to get away from the Michigan Oppression Statute, which is a very powerful statute. And here's a list of different causes of action that you can look at. I always think shareholder oppression should be at the top of the list. But breach of fiduciary duty is a lot more powerful than I think a lot of practitioners recognize. And a case that's actually cited under fraud by omission is one of my favorite plaintiff's cases, and that is Production Finishing versus Shields. And what that case basically says is Brother Joe owed a duty to his 4 siblings. But Brother Joe found a great opportunity from Ford Motor Company, and he thought, do I want 20% of that opportunity? Because I got to share 80% of it with my siblings, or do I start up new XYZ Corporation and take that new opportunity for my new company? Well, I happen to know it's a 1987 case, and the plaintiff's lawyer in that case, Dick Ray, from Chicago, argued this case in Michigan. I met him on a different case, one of the best, finest lawyers I've ever known. He lost in the trial court and appealed, and he wrote such a great appellate brief. The Court of Appeals not only threw out the jury verdict, but instructed the trial court to enter full judgment in favor of his clients. And what the Court of Appeals ultimately held was Brother Joe had no right to create this new company and to usurp that opportunity for himself. So he lost the entire profit from that opportunity. And all of that money was disgorged to effectively, and I'm doing this by analogy, the other shareholders. So in this situation, it would be Joe's 4 siblings got all the money. There was a case in California where there was a divorce, where there's a fiduciary duty that arises out of trust and confidence and control. So in my hypothetical, Joe clearly owes a fiduciary duty to his siblings. And what happened in this California husband and wife situation, wife wins lotto while they're married. Doesn't tell her husband, divorces her husband, doesn't disclose it in the divorce. Judge says, sorry ma'am, marital property, you got to share half of it. Oh no, but because you breached your fiduciary duty, you lost it all. So 100% of that was disgorged. Fraud by omission is also very powerful in Michigan law, especially the case law that holds that once you speak, you have a duty to speak fully, completely. You can't just give a half-truth. So what I like to do in oppression cases is to get my opponent to commit, ask lots of questions. What's the value of my client's stock? ask for financial information. The more questions you can ask, the more answers that you get. And if those answers aren't the full, complete, total truth, you've got a silent fraud claim and you have an oppression claim. So another weapon you have, a lot of times you don't know because there's little information. The siblings don't know much about what's happening. So what you want to do is you demand to see records. And under Michigan law, the books and records statute is powerful. And we have sometimes filed lawsuits just to get the books and records as a way to set up a later oppression. These oppression cases often come down to how you define oppression. And one of the things that gives the oppression statute great power is that you can recover for direct harm to the shareholder. Not just harm resulting to the company, it's the harm to the shareholder as a shareholder. So things like not getting a fair share of dividends or a fair share of distributions. But what these cases often come down to is the very first bullet point. Did Joe commit activity that's illegal, fraudulent, willfully unfair, and oppressive to the corporation or to the shareholder? And so there's a lot, the big fight is over what does willfully unfair and oppressive mean. That's usually the big debate. So it's pretty easy to know what's illegal or fraudulent. But for willfully unfair and oppressive, the statute states that it's a continuing, and it's under D sub 2, a continuing course of conduct or significant action or series of actions that substantially interferes with the interests of the shareholder as a shareholder. So it can be withholding key information, withholding distributions. It can often be where Joe favors himself over his siblings. Runs personal expenses through the company. That's common. Uses company assets or employees of the company to build his 12,000 square foot home. That's a classic example of oppression. Here's some more examples. Diverting funds to outside companies, related company abuse. We see this all the time. Be very suspicious if it finds out that Joe not only has the family business, but now he's got 3 more. Where did the capital go for the 3 more? Where did he get that from? What resources has he diverted from the traditional family business to the 3 other businesses that he created? Withholding information. And where this, what I've seen in my practice, it's very, very common, is the person who's in control of the company at first wants to do the right thing, shares the right amount with the other shareholders, but particularly in families becomes resentful if he or she's the one doing all the work. And then what happens is they're like, wait a minute, mom and dad passed, I worked my butt off for 10 years, and all 4 of you make the same as me? That's wrong. And so what then happens is that starts rationalizing more and more and more compensation for Joe and less than the siblings. Now, some of that's legitimate. Joe has a right to be rewarded for the work that he's done. He has a right to be compensated. And where you draw the line between what is fair compensation and what is not fair compensation, that's where Tom Frazee comes in. And I've had the pleasure of working with Tom now for many, many years. Tom is the best expert in Michigan, bar none. And he's also great at not just being the guy who comes in and testifies as to what the damages may be, but he can help you figure out whether there has been oppression or not. And he can help you frame the questions to ask Brother Joe So that Brother Joe ultimately hangs himself with his answers. And he was our expert witness just last week in Chicago and absolutely smoked the other side. So I had to give you that plug, Tom, because you absolutely heard it. It's important to keep in mind that the Oppression Statute gives courts extraordinary discretion and power. I have seen on the same facts, very similar facts, some judges say that's clearly oppression. Other judges say, I don't even think that's even close. So it's really important to know who your judge is, how your judge perceives these kinds of cases, and so you have better information going in on how to frame the issue. In Oakland County, for example, you can see all the business court decisions on oppression and really get a good sense of how those particular judges approach it. So just know the judges have extraordinary amounts of discretion. And the way these cases, in my experience, are usually resolved is through a buyout or divorce. So Joe, you see this as your company, you want to run the company the rest of your life, that's fine. Buy out your siblings, pay them fair price for their shares. Now, that's where the devil in the detail is. What is the fair price? That is often litigated, and where do you go for that? You go to Tom Frazee. And although I found that when I'm on the plaintiff's side, the fair price is higher, but when I'm on the defense side, he comes up with good ways to figure out lower. So Tom does a great job on both cases, but that's the battlefront on what is the fair value. And that's a clear, logical, simple way to resolve these cases. I'm now going to turn it over to David Hansma, and David is an outstanding lawyer. I can say that because I sat as an arbitrator not long ago on a case where he represented the plaintiff on an oppression case. And now I'm going to hear him talking about what to do on the defense side. I don't know, am I going to have to change my mind on that decision and have to reevaluate it since he might be singing a different tune this time? No, seriously, David's a fine lawyer, and the podium is yours.
Powell did an excellent job as my arbitrator too, because we walked away with a $3.5 million award in favor of my client. So, thank you, Powell. Before I start, I'm going to echo something Powell said too. I totally agree with him. Number one, that Tom is a fantastic expert. Tom was my expert in that case. But there's a lot of guys around town that can value a business, but there's a lot fewer guys that know how to value a business in the context of a shareholder dispute. I think this goes for just about any kind of cause of action, but especially in shareholder cases. Getting an expert that understands the case and understands the law and understands the cause of action is so important, rather than just grabbing any business valuator off the street that you can to come in and value the equity, because there's a lot of things going on. So right at the beginning, focusing on your expert is key. But my main point that I want to make is that sort of what Mark said, there's a lot of cases now, Oppression Statute I think is 29 years old, there's a lot of cases now under the Oppression Statute, but the vast majority of them are unpublished Michigan Court of Appeals decisions or Michigan Business Court decisions or federal decisions. There's very few binding published cases in Michigan telling us what the Oppression Statute means. And unfortunately, a lot of the unpublished decisions disagree with one another, and some of those go pretty far afield, in my opinion, of what oppression actually is. And as practitioners having to deal with a body of unpublished case law, we're kind of stuck with these decisions that, is this really what the law is? And I think in some of the cases, it's not. So from a defense side, I think one of the most important things you can do is know the law better than anyone else in the room. You want to know not just the oppression statutes, not just the oppression cases, but you want to know Michigan corporate law as a whole. You want to know it comprehensively, coherently. You want to understand the gestalt of Michigan corporate law, so you know how the oppression statutes are really supposed to be applied. And that starts with understanding that the oppression statutes arise out of larger statutory schemes. So like any other statute, they should be read harmoniously with the entire act that they fit in. And I want to pick on a case that was on one of the earlier slides, is Berger versus Katz case, because in that case, the plaintiff was alleging that he wasn't getting paid any distributions, that defendants were paying themselves these big bonuses while claiming there wasn't money to pay distributions. It's very similar to Powell's example, some of these classic fiduciary duty issues. Then there's also some lines in the case where the court says, the plaintiff was being frozen out of management of the company, and he wasn't allowed to participate in the affairs of the corporate affairs. And there's some other decisions, unpublished decisions, that make the similar point. Bromley versus Bromley is one of them. And you look at that and you say, well, is that really an element of oppression? That by itself, being frozen out of management of the corporation. And if you read the entire Business Corporation Act, you say, well, who gets to manage the business? It's the officers and directors. Shareholders don't have any right to individually participate in the management of the company. They get the right to vote on directors. They don't get to win. They don't get to be involved. There's nothing in the act that says that. So then you look at the common law, because the oppression statutes arise after 150 years of shareholder common law cases. The Matagula decision does a really good job of explaining how the oppression cases sort of arise from this equitable shareholder action in common law. All the stuff that plaintiffs sue for now is stuff that they've sued for in common law, whether or not breach of fiduciary duty, or dissolution, or injunction, or fraud, or whatever it is. All this stuff has been litigated for 150 years. There's nothing new under the sun. So you look at Berger. Berger cites a case of Salvador versus Connor, which was cited earlier, for the proposition that the majority owes the minority a duty of absolute good faith, which is all good and well. But if you keep reading the common law, you discover that Michigan has a business judgment rule. You discover that courts aren't going to interfere with the management of the company unless it arises to the level of bad faith. And bad faith is typically defined as fraud or breach of trust. It's not any old change in the status quo. So now you're looking at the act and you're looking at the common law, and you have an argument to tell the court, these unpublished cases that plaintiff is relying on, not only are they not binding, they're just not persuasive. You should just ignore them. Similar to this point is Delaware law is useful as a defendant. Delaware law tends to be pro-management, pro-defendant. It also does just a better job a lot of times in Michigan law articulating corporate law principles. So issues of what is good faith, what is the business judgment rule, they all exist in Michigan, but then you look at Delaware law and you read it and you go, oh, now I get it, and now I can better apply it to Michigan cases. Delaware is also a good gap filler for Michigan. Powell mentioned the shareholder demand for books and records. And that statute says that the shareholder can bring an action if the corporation unreasonably restricts access to books and records, which means they can reasonably restrict access. Well, what is reasonable restriction? Well, you'll look in Michigan law till you're blue in the face and you won't find a case telling you. But you look in Delaware law and you'll see all sorts of cases on it. And you learn, hey, I can make this shareholder sign a reasonable non-disclosure agreement before I just open up all the books and records to this guy who's never been involved in the company a day in his life. So, you know the law, you understand it comprehensively, your client's been sued, you're called upon to defend. Where does your defense start? It obviously starts with the elements. These are statutory causes of action, so they have statutory elements. These are quotes from subsection 1 and subsection 3 of 1489, and they really list out what the elements are. Number 1 is standing. A shareholder may bring an action, and we have a published case that says plaintiff must be a current shareholder. And that's not always an open and shut issue. Tom and I had a client earlier this year. We were helping him negotiate a buyout of this family business. And then there's another family business over here. And he's like, well, I think I'm a shareholder of that one, or I was. I sold my equity back to my dad in the 90s. Or maybe I didn't. I don't really remember if we closed on that. And he wants to drum up a reason why he's a shareholder in that company. You know, he wasn't able to convince me, but you know, he thought he maybe was. And you look at Patel versus Patel is a decision from June, I think, earlier this year. It's an unpublished Michigan Court of Appeals decision. And there was a lot of litigation in that case, whether or not the plaintiff was still a shareholder, because he had signed some sort of napkin release saying, I don't want anything to do with this company anymore. And they argued that he either waived or was stopped from asserting a shareholder interest. And the Court of Appeals agreed. So, you know, right off the bat, as a defendant, you can look at this and say, okay, this family business where no one's even keeping records, are these guys really even shareholders? Who do they sue? They sue directors and those in control. Again, it should be obvious who the directors are, but because these are family businesses or they're closely held, sometimes it's not clear if there is a board of directors. Control is typically a question of fact, but at least in the Missouri decision, the Court of Appeals required them to plead facts to show control. Because in that case, they were suing two defendants who together had a 40% stake. And the court said, well, 40% isn't control, so what other facts do you got to show me control? And there wasn't anything in the complaint, so dismissed. But as Powell said, the main argument is always going to be over, is this oppressive, right? Francino versus Francino, it's a published decision. It's been abrogated in part by statute, but it's still binding law in Michigan. And that's really the case that defines oppression. And it says, substantially interferes with the interests of a shareholder as a shareholder means the interests of a shareholder that a shareholder automatically has by virtue of being a shareholder. So it's not the interest that they maybe traditionally have in this particular company. In that case, it was employment and a seat on the board of directors. The court said even though shareholders in this company had always been employed and always had a seat on the board of directors, that's not an interest of a shareholder as a shareholder, and therefore if they fire you or kick you off the board of directors, that's not oppression. Madagula versus Todd has, I don't know that I'd say expanded, but has clarified that to some extent, that your interest of a shareholder as a shareholder includes your rights and interests under the Act, the Business Corporation Act, or the LLC. It also includes your rights under shareholders agreements, which are adopted pursuant to the Act. So I don't know that Francino would have disagreed with that, so I'm not trying to say it's an expansion, but it's certainly a clarification. But then you have cases like Blankenship versus Superior Controls, which is out of the federal court, and Bromley versus Bromley, which I think was a 2006 decision out of the federal court, that just says oppression is a breach of fiduciary duty, and a breach of fiduciary duty is oppression. We just look at them the same, we treat them the same, it's the same elements. We don't delve into any sort of difference. Those cases really focus on the language unfair and oppressive, and haven't really looked so closely at this interest of a shareholder as a shareholder. And I think, frankly, that that's incorrect. I don't think that that's consistent with published decisions in Michigan. Well, where does that leave us then with the Berger example, where you've got sort of classic oppressive action, or things that were traditionally breach of fiduciary duty, taking all the money for yourself and not paying dividends. That's been a cause of action for forever. But then you've got all this other stuff about, well, he's not letting me be in management, and he doesn't let me have a voice in corporate affairs, and is that really oppressive too? I think the answer is no. I think that the best that a plaintiff lawyer could argue is that that is maybe evidence of the bad faith nature of the financial things that are going on. But to the extent that a plaintiff lawyer wants to argue that that by itself is oppressive, and therefore, defendant freezes me out of a position in management, I can now bring an oppression claim and force a buyout of my shares. I just don't think that that's correct at all. I think that the published decisions, especially Francino, just obliterate that argument under the unpublished decisions. Which really brings us to, a number one argument for a defendant in any sort of shareholder case is business judgment rule, right? Business judgment rule all day long, every day, all over the place. Because the business judgment rule presumes that the acts of management are valid and are in good faith unless the plaintiff comes forward with some evidence that they didn't reasonably inform themselves, or that there's a conflict of interest, or that there's some other bad faith, which again is more than just any old change in the status quo. It's fraud or breach of trust. In Michigan, there's actually a heightened pleading standard for business judgment rule cases. Plaintiffs have to plead facts in avoidance of the business judgment rule. It's not normal notice pleading. So right there gives the defendant an opportunity to bring a motion to dismiss. It's also, interestingly, I think you can make a textual argument under the Oppression Statute that there's sort of a business judgment rule on steroids, because ordinarily, the ordinary common law is that plaintiff proves facts in avoidance of business judgment rule. Burden now shifts to directors to prove the entire fairness of their action. I think you can make a textual argument under the Oppression Statute, and I'm not aware of any court that's done this yet, so maybe it'll happen one of these days, but that the burden is always on the plaintiff, because it says a shareholder may bring an action to establish willfully unfair and oppressive. That's the abbreviated statement of what the statute says. So the plaintiff has the burden to establish unfairness. So I think you can make a textual argument that there's never a burden shifting where a defendant has to prove entire fairness. If you want a burden shifting analysis, then you have to proceed under a common law fiduciary duty claim, which brings with it other procedural hurdles, including the fact that most of the time, those claims are going to have to be brought derivatively, and you're not going to be bringing this powerful direct action that the oppression statute allows for. Really, my last point on this is just remember, these are equitable statutes. So even though you've got your legal arguments, business judgment rule, standing, whatever it is, case comes in the door, you're defending an oppression case, you got to start thinking right off the bat, what is the fair and equitable and just result that the court is trying to grant in this case, and what is fairness in the context of this entire case? Even if it's not your burden to prove fairness, you're going to want to put on a case in chief, obviously, so you're going to want to start thinking about what are the facts in this case that I'm going to marshal to show that what my client did was fair and was not unfair to the plaintiff. And if you're going to lose, and frankly in oppression cases, you got to plan for the inevitable, occasion where the plaintiff is going to win. Because I think that in a number of cases, particularly in certain arbitrations anyways, there's going to be a bias towards wanting to find a remedy where the court or the arbitrator can separate these people. They're going to want to find a way. Even if it's a little iffy, they're going to want to find oppression just so they have an excuse to buy the plaintiff out and get these guys away from each other, to divorce these people. So, as a defendant, you're going to want to start thinking, okay, if I'm behind the 8 ball already, if there's a bias in favor of wanting to get plaintiff out of this business, what arguments am I going to marshal to show that the panoply of, I think I mispronounced that word, that the remedies that plaintiff wants to bring, or that plaintiff wants the court to impose, what arguments am I going to make to show that those are unreasonable? And the example I used last time we did this, and I'll use it again, is that Mark's Castle case, one of the elements of oppression there was that the plaintiff didn't get to vote on certain capital calls, which may be oppressive under the Madagula decision. But let's say that's the only piece of oppression that plaintiff has, right? And now a year and a half has gone under the bridge, and we get to a judgment, and now does the defendant have to come up with whatever it is, $1 million or $5 million or whatever it is, to buy out plaintiff because plaintiff didn't get to vote on the final? Isn't the more just and equitable result in that case an injunction that says don't do that anymore, maybe rescission of whatever the act was that he didn't get to vote on, whatever it is? The point is that as a defendant, you want to use the equitable argument to your advantage to say the court isn't required to grant plaintiff every single remedy that he's looking for. And to that end, I think the party's business deal, whatever their deal was, whether it's written down, it's a formal shareholder agreement, whatever it is, these are closely held companies. It's usually a handful of people, or maybe only 2 people. What's that? Oh, I thought you were asking a question. Per your instruction earlier, just a shout out. I thought you were answering a question.
That was the 5-minute.
That was the 5-minute one. Okay. It's usually a couple of guys, so they're going to have some sort of deal. They're going to have some sort of arrangement that they're operating under together. And despite Franchino, despite the fact that it's not a reasonable expectation test, I think a court or an arbitrator is going to be persuaded by which of these parties is departing from whatever the deal was that these guys had. And whichever guy is departing from the deal is the guy that's acting unfair. So if you're the defendant and you have departed from that status quo, you're not going to want to rely on just the Franchino argument. I can do it, Judge. It's not an interest of a shareholder as a shareholder. You're going to want to start thinking about what are my facts that I can show that I had a business reason to depart from this status quo and that it's fair for me to do so. And then my last point, which I thought was on the slide, but it's not, is just there comes a point in defending oppression cases where, as a defense attorney, you need to take off your advocate hat and put on your counselor hat and sometimes tell your client to hold their horses and to calm down with whatever they want to do. Because you see it all the time where they're freezing out plaintiff and plaintiff sues, and then the defendant says, hey, you thought that was bad, watch this. Because my lawyer explained Franchino to me, and you ain't got no rights, so I'm going to do this, and I'm going to do that, and I'm going to do the other thing. And even if legally that's correct, as the attorney, you go, hey, you're in an equitable court. You're in front of an equitable judge who's empowered to do equity and has a fairness standard. You pick now, of all times, to ramp up the aggression and really just push that envelope of what you can get away with. And you see lawyers that's just going to court saying, absolutely, Judge, he was allowed to do that. have an obligation to tell your client, maybe just don't do that for the next 6 months, and let's just get through this case, and then you can do whatever you want. There will be a judgment. So I think that was the last slide I had. Yes, so next up you're going to hear from Frazee, who is, I think, has a number of various initials after his name, but he is a business evaluator. He's been my expert in a number of cases. He's been Powell's expert in a number of cases. He's been Mark's expert in a number of cases, and he really is the best guy in town for doing business valuation in a shareholder case. He obviously knows how to value business, but he also knows the Oppression Statute and the case law as well as a lawyer. He was like my co-counsel in my last case. He did a great job.
Thank you, David. It's going to run out of money paying these guys tonight. Thanks for having me here. First, before I get started too much into what I'm going to talk about, let me just ask this question. How many of you in the room would be able to talk about business valuation for more than 2 minutes and still have content? And this is a serious question, so I'll help you guys cover things. All right. Okay, good. All right, so I run a firm that does valuation stuff. I've been doing shareholder disputes in Michigan for about 22 years. I think it was almost right out of college I started working on cases like this. And frankly, many of the cases that you may see as being on the appellate list or recent decisions I've been involved in, either the consulting role or as a testifying expert. Very quickly, I'm probably unique in this room in the sense that pretty much everybody here is an attorney, and therefore you are allowed to be an advocate. My role in a courtroom is to assist a fact finder, and in a shareholder case that's going to be a judge. But my job is to assist the fact finder in understanding what I do and what my opinions are related to a topic which they may not have a lot of expertise with or experience with. And so I'm not advocating. I'm there to present my opinion. Obviously, there's going to be an attorney on the other side of me who doesn't agree with what I have to say, but I'm still not an advocate. I am there to inform and to assist the court. And frankly, Paul mentioned the arbitration in Chicago, which was before a panel. And really, I thought it was a great example of a situation where there were two different experts that were there to speak on the question. But at the end of the day, our jobs both were the same, which was to educate the panel on a topic that they weren't naturally focused on or aware of. And so that, again, is really the key. The reason I bring this up, though, is that we get criticized. Appraisers get criticized because judges get two appraisers in the courtroom and they come to very different conclusions, and the judges look at those opinions and say, wait a minute, aren't you really being advocates? Why, I thought your job was different. Why are you at $4 million and you're at $23 million? What's the thing that's going on here? And the reality of it is that many times appraisers that come into a shareholder case are going to get very similar sets of facts, documents, testimony, information, so on. There is asymmetry in the sense that usually a defendant that controls the information is going to have more to provide to the person that they retain as an expert. But in any event, there's a lot of symmetry in the information that's being considered. But there are some very important things that an appraiser looks at and considers when they form their opinion. And if there are differences in the focus, differences in these factors, which I'm going to cover here in a second, that can lead to very, very different results. So first, valuation date. I am unaware of any trial which has been concluded in less than 6 months after trial. So at a minimum, you have a scenario where you've got an oppression claim, complaint is filed, someone says, as of yesterday I was being oppressed, here's the complaint. That doesn't get presented to a fact finder for at least 6 months, usually much longer than that. And so the first question that comes up is, what's the valuation date? What are we using to set the value? Is it back in 2010, or is it in 2013 when we get to trial? Had a case where the subject business was a steel, had a large steel inventory. huge question as to what the value was on the date the trial started versus the date the complaint was filed, because steel prices had gone up 40% during the time frame. So valuation date is very important. A second thing that's very important as well, and obviously we're talking about an oppression statute which protects minority shareholders. And actually, before I cover this, let me back up because I don't think we talked about this yet. The Oppression Statute in Michigan provides for a variety of remedies, lists a number of those remedies, but it also gives the judge equitable powers to choose another remedy. But the two that I'm going to focus on are the ability to award damages and a separate line that says, and or determine the fair value of the shares. So, minority interest plaintiff has a claim. One of those realistic and usual and typical prayers for relief involve a redemption of the minority interest that they own. So the question is, how do you reflect the negative features of a minority interest as opposed to a control interest in a closely held company? And this is an important part of an appraisal process. So if you typically look at a phrase, fair market value, everyone in this room has heard that. It's used in all kinds of statutes. It's used in the Internal Revenue Code. It's got definitions. There's all kinds of books on the phrase fair market value. Fair market value in many situations reflects the value to a hypothetical buyer or a hypothetical seller, not under compulsion to buy or sell. They're going to receive cash for whatever it is that they're selling. Well, frankly, most of those things break down. And secondly, the statute specifically says fair value and not fair market value. So the first question for an appraiser is, well, how do I sort of take off the hat that I'm used to wearing that says, give me the fair market value of something? How do I move into this world of fair value, which the statute doesn't define, and which the case law, frankly, doesn't typically define very well in Michigan? What do I do to adjust my thinking on this? And so the typical fight between an appraiser who's valuing the minority interest, the plaintiff's appraiser is going to look at that and say fair value is going to be determined by valuing the company and then multiplying that value by whatever ownership percentage you have. So if you have 12%, you come up with the value of the company and multiply it by 12%. A defendant's appraiser will typically argue that discounts apply. Discounts, specifically spoken of a lot of times, are referred to as discounts for lack of marketability, meaning you can't quickly sell your shares, and you always knew that as a minority shareholder in this company. And then the second is, there's also a discount because you don't control anything, to which the plaintiff's counsel replies, yeah, that's why we're here. But the point is that that fight between those two perspectives, is there a minority and a controlling interest discount, minority and a marketability discount, that gets sometimes manifested very specifically into the two appraisals. One has it, one doesn't. But it can also be built in. It can be built in by the assumptions that an appraiser makes about whether or not the controlling shareholder is ever going to change their behavior. In other words, I've been paying myself $1 million a year for a long time. Why should we value the company assuming that I made something more or less than that? You don't have any ability to change it. It is what it is. Value it as it is, as opposed to what you would prefer it to be. So this kind of issue comes into the discussions, and it affects many of the different decisions that a valuation person or appraiser can make. Quickly on methodologies, 3 basic methodologies used in most appraisal assignments. The income approach, which focuses on the future. What income would an owner earn if they continue to own an interest in the business? So you start with a normalized set of, you start with historic numbers. Whatever's happened in the past is relevant. It's relevant to forecasting. Number 2, you begin to make normalizing adjustments. In other words, things that are real simple like, hey, we're not going to get an insurance settlement every year because hopefully the building doesn't burn down. Or, maybe we had a one-time change in our tax structure a couple of years ago. So things like that. Normalization happens. But here's where the rub comes in. Normalizing for the same thing that the plaintiff is complaining about. So, Powell mentioned the 12,000-foot house and the silver Ferrari. I've had a client that actually had that exact same fact pattern. And the question was, the reason you have such a nice house is because you had your construction crews out working on the house, kind of on a pro bono basis. And so we made zero profit on all that work. Is that something that should be normalized out and removed? So there's going to be but there's a fight, because on the one side the defense says I'm allowed to do that. Maybe it's business judgment based. Maybe this is the family tradition. There could be a lot of reasons for it, but that's an issue that I will look at. So I'm looking at it not only because it affects the question of how do you normalize income and therefore determine the profits relevant to the valuation process, but it's also relevant to damages, which might have occurred prior to the trial date. And this is important, it's also very relevant to the question of ultimate liability. In other words, getting to this question of what is willful, unfair, oppressive, those kinds of activities matter. Related party transactions are typically, frankly, where you see the problems coming up. All right, second approach, quickly, frankly, rarely used, except in certain situations, is an asset-based approach. What can you touch and feel? If you were looking at a company and this is what it had, and it had three smart people that sat on the other side that practiced medicine, the intangible value created by those folks is significant. The value of the cup, the water, the microphone, the table itself are small, but there are other businesses where it's exactly the opposite, very asset intensive. Obviously real estate, holding companies would be an example of that, but there are frankly many manufacturing companies that have way too much in terms of assets versus the amount of profit that they produce. I bring this up simply because of this, and I've got a case that's up on appeal right now. The fundamental issue was you had a company with 50 or 60 or 70 or 80 million dollars worth of stuff, tangible stuff. It was valuable, there was no question about it. But the way the company was run, it was producing income at very small levels, and if you applied an asset approach, you come up with 80 million. If you applied an income approach, it would look like the business was only worth $20 million, which is the determinant of fair value, okay? If you're a minority shareholder, you obviously can't access the ability to liquidate those assets out and take part in an $80 million type business. All you're getting is a measly dividend check or maybe no dividend check at all. And so there's a question here that's relevant to the appraiser who's tasked with determining fair value. Do I rely upon an asset approach, or do I focus on that income approach analysis? To mention this quickly, Mark, how much time do I have? 10? 7?
5 minutes.
5, okay. So damages, as I mentioned already, are part of the game, part of the process. Typical examples already mentioned here: distribution, starvation. We have money, we choose to keep plowing it back into the business, okay. Business judgment rules and those kinds of arguments come into play. Diversions of corporate opportunity. How many side businesses have you set up? If they interact with the business in which you share ownership with others, was that an opportunity that you offered? Was it an opportunity that the business was capable of handling? There's a series of cases that deal with it. That's a typical issue. Excessive compensation, the classic one. It comes in all different shapes and sizes. The excessive compensation argument can be the CEO is making way too much. It can also be that that was done by agreement for many years. And how do you consider that as part of the appraisal process? And one of the other things that's pretty interesting to me is sort of an outgrowth of the statute change that followed Franchino is what happens when you fire the plaintiff, who then turns around and sues, and then wants to focus on the idea that the business's value has dropped because they're no longer there. Classic example would be a scenario where this head salesperson, now there's some damage to the business because that person is no longer involved. Is that a defendant's a problem now, not only from a liability perspective, but from a damages perspective as well? All right, let's skip this one. All right, let me get to 5 interesting questions that I have seen over the years in a variety of cases. So this one is, does a finding of liability create a liquidity event that didn't otherwise exist? So one of the things somebody's going to talk about tonight most likely is the existence of an advice to get a buy-sell agreement put in place at the first moment that you form a closely held business that has more than one person. Okay, fine, put it in place. It has all these fancy formulas in it. I got a call on one of these yesterday. And the question was, what do I need to put into this thing to make sure that this formula sort of approximates market value but gives some specific rights and triggers if the parties ever get into a fight with each other, or they get to go through a divorce or bankruptcy or whatever. And at the end of the day, when you're a plaintiff asking for relief under this statute, one of the things that you're almost always asking for is, get me away from that guy or that lady. I don't want to be a partner or a shareholder with them anymore. I need my shares to be repurchased. And it's not just a money grab, okay? But nonetheless, the point is that you can ask for that relief, even though that relief and that sort of right and what you're asking for as fair value never was existing in the shareholder agreement that you signed 15 years before that has provisions in it that says, here's how you do the buyout. So anyway, that's an interesting issue. It comes up almost all the time. Here's another one. Should contractual mechanisms interact with fair value determinants? If you ask an appraiser to come in and normalize the cash flows and then come up with the value, the first thing they say is, well, what's the compensation of the owners, and are there any related party transactions in there? And the adjustments that are made as a result of hearing, oh yeah, there's lots of that kind of stuff going on. The adjustments are huge. And then you turn around and you say, well, wait a minute, weren't you the same person who signed the lease 20 years ago that allowed for that thing, that lease stream? Or didn't you vote to approve the compensation package for the CEO? And yes, maybe he's a little over the board now, or overboard with his numbers, but you've been involved in some of these decisions in the past, or maybe Grandpa told you had to do that, so that's the way it's been working for a long time. Why are you upset about it now? So the issue, again, is not just a liability question, it's how does an appraiser consider the fact that the market rates for these services might differ hugely from those provisions in another agreement. I used the buy-sell agreement as an example, but there are other contractual ways that economic terms can be set. Death by 1,000 mosquito bites. So I went camping a couple times this summer, and it's not death by 1,000 cuts. This is much worse. Mosquito bites are hands down worse. But this is an interesting thing that interacts with the Linkner case, which is basically this. You can do things one at a time, or one step at a time, and as long as you let a little bit of time elapse, you may be able to get away with it because there's no damage yet. It's the cumulative effect of the mosquitoes that kills you, and it's the cumulative effect of decisions that can really cause an oppression scenario to manifest and to actually create damages that you can measure. But I was involved in that case, in that Linkner case. I didn't get to the stage of having to issue a report. But the problem in the case, and the problem that an appraiser will face is, let's say you have a plaintiff who wins. This was an oppressive act. What are the damages? We don't know yet because the manifestation hasn't yet, really come home. So how do you deal with that? You just go and get a judgment that says, hey, you're successful. Here's your check. It's zero. Interesting issue. Number 4, should non-actionable decisions be considered or ignored? So this actually kind of goes back to my earlier example. There are many family dynamics where grandpa gets paid if he doesn't show up or he does show up, where the junior generation, whether it's second or third, gets paid little even though they deserve more. Maybe that's the reason they're in the shareholder case in the first place. But the point is that a lot of times there are agreements in place that say, this is the way that this business shall be operated from a financial perspective. Again, the question becomes, does an appraiser take that and assume it to be relevant for the valuation process, or do they start with a fresh sheet of paper and say, look, my goal is to determine what the economics of this would be to someone who had no sort of interest in distortion or anything other than just an arm's length set of relationships. How do I value the company? And this is my last one. Is a plaintiff that proves oppression entitled to be bought out at fair value? So David mentioned this point that many times you do find situations where an arbitrator or a judge, even for that matter, may not be fully convinced that an oppressive act has occurred. But they cannot apply the equitable remedy of buy the shareholder out unless they find that there was oppression. And so what happens? You get someone who comes in and says, this is my determination of the fair value of the company, and the defendant comes in and they offer testimony that is not fair value. They offer testimony on fair market value. It's X dollars minus this discount, this discount, this discount, et cetera, And we want we want the fact finder to award something based on fair market value. And so let's argue about that. And the answer, frankly, is if you're a defendant and you haven't been found liable for the event, what are we talking about? Why are we talking about fair market value plus discounts? So I'm not saying that there's a right answer or a wrong answer on that, but that's one of the issues comes up in every case. Defendant's going to talk about a discounted value, whether it's equitable or not, it's a separate question, but something that pops up frequently. I think that is it. So Frank is going to talk about when someone else takes over the process of running the business. This is one of the remedies under the statute. And yes, and it happens all the time.
Just a quick reminder, if you weren't here at the beginning, the cards that were passed around are going to be collected after Frank speaks, and it'll give you a chance to ask the judge questions instead of the judge asking you questions.
Thank you. Thank you, Tom. I'm Frank Simon, and as Thomas mentioned, the receivership is one of the remedies with regards to shareholder disputes and really many types of other disputes. Just a disclosure here, it is not often that a receivership is granted, and particularly in a shareholder matter and case. They are usually more often granted in other types of actions, but they're granted, but it really is a rare occurrence and a very unique remedy that obviously is considered almost as a last resort to appoint a receiver in a shareholder dispute. And the reason being is there are many other alternatives to resolve the case frequently. So the courts look at the receivership really as the last possible option for the most part, and again, particularly in the shareholder dispute. So when there are cases involving shareholder disputes, it could really vary to almost any industry. So we have handled cases involving a chain of a dozen or so of hotels that are around the state and outside of the state, but it could be any type of a business where a receiver could play a role. And just because you have a dispute in a shareholder matter or an oppression, it could really fall into any type of category of an industry. We've handled shopping centers, restaurants, golf courses, party stores, healthcare and staffing companies, IT companies, physical therapy companies, manufacturers, and really almost across the board, almost any type of industry you could think of that a receiver can be appointed on involving a dispute. And so obviously the circuit courts are the ones that mainly appoint receivers, and it could be done on an ex parte basis as well. And usually, again, it's a very rare occurrence, especially for an ex parte basis. I've only seen it a few times where a court grants, particularly a TRO, it's almost never granted a temporary restraining order on a receivership matter. A lot of times the factors appointing a receiver involve fraud, and these fraud elements really occur, as mentioned earlier by some of the speakers, involving the shareholders doing certain things that are considered to be really oppressive, and fraud is obvious, and it's causing lots of risk to the company. It could be even a scenario where the company is really being harmed, tremendously, and it needs somebody to come in and be appointed receiver to take charge of the company and run it in an appropriate way. So the key part is to protect and conserve the business. Again, any type of business, it could be really that's mostly ongoing and operating. A lot of times what we've seen are shareholders who have entered into leases with, particularly with family members or relatives of theirs that are under market or priced not in a fair market value, and so the company is being severely harmed by that action, where a receiver could come in and terminate that particular contract and or lease. But we definitely have seen many of that type of action where these leases, these contracts come into play, and it is some degree fraud and made into a situation where it's helping a family member, perhaps because they're having some financial difficulties or there is some other factors. But termination of leases or contracts is an area where a receiver could come into play and try to terminate that scenario. So there's been several cases out there involving receivers where it indicates that the shareholders are committing fraud, and a receiver can be appointed. The receivers really, there's many people out there that I'm sure could handle receivership type of work. So a lot of the knowledge and skill really involves somebody that has some knowledge of bankruptcy, finance, and just the overall receivership rules and case law. Most of the time, the receiver has to have a bond, whether it's a blanket bond that already exists among different counties, and or selective bonds that needs to be posted to the court. Someone with had a track record with the courts that have some resources that could handle ongoing daily issues and activities and litigation. We've seen lots of litigation involving receivership where we have to handle 10, 15, 20 cases that's ongoing involving that particular matter and or company. We've had a scenario where there were at least 20 lawsuits filed against a company that we were a receiver of that we had to dispose of and handle accordingly and get involved with almost each one. So someone that has some litigation experience definitely helps. A receiver could also hire lots of professionals really to assist when needed. It could be a valuation expert like Tom. It could be a real estate broker to give you a value on a real estate, so that way it could be disposed of and or sold. There could be a forensic accounting to come into the company and review all the financials and figure out if there's any been fraud going on or if there's been any shenanigans with all sorts of monies being siphoned out from the company. So forensic accounting folks, we have found to be really a key factor because we actually have hired many of them, and it's just remarkable the things that they could come up with and find that otherwise it would really be hard to pinpoint without them going into the records and finding all sorts of things that it's just very surprising. So many of these disputes that we've come across, they have all sorts of 3 sets of books or 4 sets of books. And you don't know which one is legitimate until you get a CPA in there for forensic accounting to figure out which ones are the legit book of numbers that should be shared. Some of the duties and the powers of the receiver involve paying taxes or paying certain creditors or not paying certain creditors. That's not the case. So as a receiver, we got to look at a case-by-case basis and try to figure out which creditors should be paid or not paid. Usually there are a lot of outstanding bills and liabilities of the company that some could be paid, should be paid, and others that should not. And the receiver order would allow the receiver to review and figure out which ones are legitimate and which ones that we are simply not able to pay according to the receivership order. And that involves all sorts of claims as well. It could be insurance claims, a personal injury claim. So it's critical to figure out, which liabilities are ones that need to be handled and which ones could be set aside. We've seen a lot of times too in the receivership that clawbacks. The receiver could really go back and find out who's been paid by a shareholder or by the owner of the company and try to claw back those monies that were paid off that should never have been paid from the beginning. And it could be substantial amounts of money. We've had a case where we went back to a certain creditor and recovered a very substantial amount of money that should never have been paid. And at the end of the day, the receiver really works for the court and tries to make the estate as whole as possible. And we always work to try to making sure that there's been everything's been looked at carefully and everybody's made whole, and we're looking out for the best interest of the parties. So there's been a few cases that's out there. This Kostopolous Landscaping versus Lee, where the court must find that the nominee receiver is not qualified to serve, and so most of the time the courts would look at and grant the receivership that's been proposed by the plaintiffs or by the parties together, and that's been the typical arrangements. Really, mostly in the courts around here. In the Coppola versus Manning case, that's what I mentioned earlier about lawsuits being filed by the receiver to try to recover any monies that's been paid out that should never have been paid, or even there's been a breach of fiduciary duty by any of the shareholders of the parties. In the receivership, it's pretty interesting because things that you come across, it's all sorts of things every day. It could be the utility companies wanting to shut off the power because they haven't been paid. We had a case where DTE Energy gave a 48-hour notice to shut off power on a very large office complex that housed about 2,000 employees for a national company, and we had to come in and stop DTE from doing that and trying to figure out what transpired with a landlord who never paid the utility bills. But this was an interesting one where two tenants are the ones that filed the receiver action instead of the landlord, which is normally the case, to stop the landlord from ruining this office complex, and to have somebody come in and help keep these companies open. And so that's an interesting element of a new one that we've not seen in a while, where tenants actually file for receivership instead of the landlord or the company itself. We had one where a healthcare staffing company shareholder dispute. This was a large company that was about 9 states, about 1,500 employees or so, and they had offices in all these different states, but they were being sued in all these different states for employment issues, and they also had things that they were paying their employees properly, so some employees sued them for a class action, and we got involved. We found out that one of the shareholders had an arrangement with certain employees and paying them separately. It was really a mess, and we got in there and calmed the situation down and handled it accordingly and figured out what happened, what transpired, and the court finally removed this particular shareholder and did not let him be at the company anymore. And so this was a very kind of unique and interesting one as well. We had another one where there was a very large mall that had many tenants, about 90 or so, operating, and this mall had construction issues where they were building all sorts of build-outs, and the tenants ended up suing the mall because some of the main anchors have left, and it was in disarray, and the parking was in disarray, so we ended up taking that over and try to get the construction finished and get the lease. Some leases terminated, some leases we had to extend, and it was also involving several owners who owned this particular mall that were fighting with each other, and there was some oppression going on with certain ones, and so it was a very interesting dynamic. I'm gonna ask if there are any questions. I know this is a little bit unique type of a remedy that not many people have probably utilized, but if there's any questions I could answer, I am happy to do so.
Have you found that with the advent of the business courts, it's affected the manner of appointment you get, or how the receivership is managed on the docket, so that it's not there in perpetuity and it can be concluded at some point?
Sure. Yes. So the business court has been, I believe, a great situation that's occurred in the state. A lot of the business court judges understand the receivership world and the business side of things, and they do want to. The court wants to try to get these cases finalized and resolved at the outset and as quickly as possible. So we have seen that the process is a lot better in the business court setting instead of the civil court. So thank you, Mark, because my time is up, so thank you very much.
I think Dino, Kostopolous, and Ryan Plecha, you guys in the house? Dino and Ryan are going to tell us how we can avoid this as much as we should in a civil lawyer.
So good evening, everyone. heard a lot about shareholder oppression and litigation. So it involves fighting, uncertainty, fuzzy case values, time, and distraction from your business. I don't know of a single business besides attorneys that are in the business of litigation. So we're going to go through a couple steps on how to avoid oppression actions in general. Despite how fun everyone has made corporate oppression actions and litigation sound, I really want to analogize to the shareholder formation as being a marriage. But it's often referred to shareholder oppression actions as being a business divorce, which in actuality is what it is. You're separating the partners. So if you were going to have a divorce, you had to have a marriage at some point. So you want to have essentially a prenup. You want your documents to be detailed and set forth how the parties are going to behave. So that way, when everyone is playing nice in the sandbox, everyone gets agreed to what they want to do going forward, they have a common purpose, they can negotiate these terms and agree on how they're going to behave. As opposed to doing it later, hiring professionals when everyone's outraged at how the other party is acting. One other thing I want to talk about is if you need to have attorneys for not only the company, but highly recommended for the members to negotiate these contracts. I know everyone's playing nice in the sandbox, as I said. I've been in business for 20 years. I've known Sam since I was 12. You know, we can just have a handshake. That generally works to start something. It never works to finish anything cleanly. And if you can't negotiate the terms on how you're going to behave and act as partners in a business, maybe you shouldn't be partners or members in the same company. If you can't agree on how you're going to act in the beginning of your relationship, you're definitely not going to agree on how you should act at the end when someone's stealing money or building a 12,000 square foot house on the company dime. So good corporate governance starts in many instances even before the entity is formed. What type of entity are you going to have? Are you going to be an LLC? Are you going to be a corporation? What are the differences? It's very true that LLCs have morphed into and have become much more like corporations, but there are still differences. And as a fun fact, there's about 7 LLCs formed for every corporation that's formed in the state of Michigan. So they're becoming increasingly more popular because of the additional flexibility they allow to LLCs as opposed to corporations. Also, something that I think gets lost a little bit is where are you going to incorporate? Where are you going to organize your company? Because if you want to avoid Michigan shareholder cases for oppression, don't incorporate or organize in Michigan because the statutes apply to domestic corporations or corporations. They do not apply to foreign corporations. So if you want to avoid a Michigan shareholder oppression case under the statute, don't form your entity or your organization in Michigan. Documents, documents, and documents. It's a critical thing I cannot stress enough. Stay how you're going to act before you form your company. As Davidson always said, he's in the audience, don't let your clients be cheap, or at least strongly advise against it. Yes, it's going to be more expensive in the beginning to negotiate your documents, to go through the little details of how you're going to separate. But as another attorney said, expensive is cheap later. Cheap is expensive later. So really you want to advise your clients that this is a critical point in your business. You are agreeing, you have a common purpose. Act like it, get your documents in order, and that way you have a good start to your business to operate. You know what your goals are, you know what you're supposed to do, but you also have an exit strategy if for some reason it doesn't work. The devil is always in the details of these agreements. Form operating agreements, form bylaws are good for one group of people. Does anyone know who that is? It's the litigators, because it's not tailored to the business. And I know there's a lot of litigators in the room that don't want to hear that, but the more detailed and tailored your agreements are, you can prevent litigation in the future. A couple thoughts from practitioners that I'm not going to read the quote, but just to paraphrase. Retired Judge Dan Ryan from the Wayne County Business Court said, carefully crafted articles, incorporation, and bylaws. Not only have them, but follow them. Know what they say. Don't sign them and put them in a drawer. These are the rules to the game. Follow them. And if you do so, you'll be in a much better position to avoid oppression actions from both the majority side, or the control side, and the minority side. Again, as obvious as it sounds, know your documents, follow them, have them, live by them as a company. And again, make sure this is in language that everyone understands. It's not in legalese that's out of the form. The parties that are going to operate the business need to understand what their roles are and what their responsibilities are. Take advantage of statutory flexibility. Here's where the real meat in the agreements come from. The provisions you want to discuss, negotiate in your agreements so that you know what the rules of the game are going forward. And to discuss the more detailed provisions that all operating agreements, bylaws, and corporate documents should have is the managing partner of Kostopolous Rodriguez, Dino Kostopolous.
Thank you, Ryan. Good evening, everyone. Ryan hit it on the head earlier. The biggest problem that I see in oppression action in shareholder disputes, I've had the benefit of litigating on behalf of plaintiffs, I've had the benefit of litigating on behalf of defendants, and I've also drafted a lot of these agreements. The biggest problem I see starts on two issues. One, you don't have an agreement, or two, you have a very poorly drafted agreement. And I want to focus on the latter because it happens. Oftentimes you get a client who doesn't want to pay the resources, you get a proper agreement. Oftentimes you have attorneys who just use form agreements, so one size fits all. That never works. The operating agreement should be the most heavily negotiated document in a relationship between the parties. And then the third scenario that happens, the parties don't have an agreement, which is right for disaster. What happens there, there's no agreement, the statutory fallback is you go to the statute, and again, the statute is not always clear on what they have. So I want to go through what I think are a couple of important provisions. A well-drafted agreement is not going to be a silver bullet. It's not going to prevent every shareholder oppression action. What it does, though, it at least gives a roadmap, and it allows a litigator to analyze, going into a possible case, okay, what do the documents say, and what was the conduct of the parties? Ultimately, as David pointed out earlier, parties are going to act like how they're going to act. It's a very emotional time. It's a business divorce, and parties act a little irrationally sometimes. But if you have a roadmap, and if you have a well-written document that anticipates a lot of possible disputes, as a litigator, you can analyze, okay, what are we going to do with this case? Are we going to try and settle early? Are we going to go to the end, or what are we going to do? Now, the beauty of our statute is found at 450-1489, which basically says conduct or actions that are permitted by agreement in the Article of Incorporation bylaws are consistently applied, are not basically oppression if it's done for a business purpose and it's reasonable and it's not against public policy. So these are a few tools that I've seen over the years that I think are real important. And I think, again, you're not going to prevent it, but at least you're going to go through and try and kind of contain the risk. Because, again, as I think Powell mentioned it earlier, judges have wide discretion as to how they're going to deal with these cases. So you want to take that discretion away. If you have a well-written agreement and the parties have behaved in an orderly fashion and there's a business reason for what they've done, judges generally, not always, we've all had instances where that doesn't happen. Judges usually will honor the written agreement. So there's a couple, there's about 4 or 5 I want to highlight. The first one are preemptive rights. Preemptive rights are a really powerful tool. The common oppression you see is when minority shareholders are squeezed out. For example, they do the majority does a capital call to dilute the ownership interest of the minority, or they issue a new class of stock. Preemptive rights are important for minorities because it protects them. What basically does is that if a minority shareholder has preemptive rights, they are allowed to stand on equal footing with the majority. So if the majority decides to issue more shares or units of stock, the minority has the opportunity to participate on the same price and terms, and they can somewhat control from being diluted. Drag-along rights. Now, this is a powerful tool for the majority. A drag-along right is basically, many of you have probably dealt with, it basically gives the majority control in how they exit from the corporation. So, for example, if the majority gets an offer to sell the business or the majority of the shares, and they think it's fair value, then if they have a drag-along right, the minorities have agreed to it, the minority has to sell. And they cannot object, and basically they're given the power of attorney to the majority to get the deal done. Now, I want to talk about two litigations I've had related to that over the past couple of years. A couple of years ago, where we had a drag-along action where the majority decided to sell the company, and there was a drag-along provision in there. And the minority, it basically said the minority has to agree with it. Basically said you have to sit in the corner, you can't say, boo, I'm selling the company on these terms. Now, what we found, though, was that the majority was selling it to an affiliate, a related party, and it was a depressed value, and we were able to stop that right on the eve of an injunction hearing in federal court. We were able to stop that. Now, on the flip side, I represented the majority in another case. We had a drag-along right. Same issues. We said we want to sell, it's fair value, but in the agreement, when I represented the majority that we drafted, we put in there specifically that a drag-along right is only allowed to a third party that's not an affiliate or a related party. And that gets to the definition of affiliate. So you got to be really clear on when you draft these, because otherwise you give someone a backdoor to try and delude you. Tag-along rights, those are extremely important for minority shareholders. That basically gives a minority a chance to tag along and go along with the majority when they try to sell their interests. The benefit of that is a minority gets a market for their shares, and it's probably going to be at fair market value if the majorities want to sell their rights on that. And again, some other things to consider. Capital calls are a very common squeeze-out mechanism. On behalf of minorities, I always recommend a supermajority vote on as many material and substantive decisions that can be made, because that's one way. And again, the majority has to show that there's a purpose for this capital call. You can't just say, knowing that another member might not be able to make a capital call. And then again, no creation of additional classes or any amendment to the shareholder agreement or operating agreement that material adverse effect. But these are all great tools, but the point is, these got to be addressed on the front end. And I mean, we've all had it. I've had clients, they're excited about the opportunity, and they move forward with it. Then I get a litigation 2 years later, and I said, where's the operating agreement? Here it is. I looked at it. I'm like, where'd you get this from? Oh, we form an agreement off the internet. I'm like, oh, that's good. So the font's different. It's all screwed up. So that's why, if you have a client who's starting a venture with someone, you've got to stress the importance to them of addressing all these issues. And the statute gives us wide discretion to really be as creative as we can to anticipate every obstacle in the way. And I've always said that the best practitioner to draft an operating agreement oftentimes are litigators, because they know what the pressure points are, they know what the litigation points are, and if you can address as much as possible on the front end, that really eliminates the chances of a long, drawn-out litigation. Now, I did get one question from the audience I want to address. One of it said, regarding issues of conflict of interest, who is counsel for the corporation, counsel for the attorneys and parties, etc. Ryan addressed it a little bit, but usually the traditional case is that you have a majority who forms an entity, and usually counsel for the majority is going to draft the first version of the operating agreement. All the other members and shareholders should get their own counsel. And if you're the drafter of the operating agreement, you should have a disclaimer in there that basically identifies who you're counsel for and who you represent. So there's not, because we've all had it, we're down the road, you got 4 shareholders, 3 minority comes and says, well, he was my attorney, he drafted the agreement, I thought he was my attorney. So basically, everyone should be represented, everyone should have the opportunity to get counsel. Now, where there's a little litigation involved in it, the attorney who essentially acts as counsel for the corporation is technically conflicted out of any shareholder dispute, and then the majority or controlling party. Oftentimes, the controlling party is not the majority. So each party should be litigated, should be represented separately by legal counsel. So A couple other things that I just want to address really quick so we get to the question. Number one's an important one. So a lot of times you have clients who issue stock to either employees, consultants, etc. I always recommend those that they're either, if you're going to issue equity, the two non-founders or parties that come in, either create a new class of stock that's non-voting or issue them profits interest or some equity interest that doesn't allow them to vote. Because that's one way to avoid oppression claim is you don't have, the more you reduce your minority shareholders, the more you increase the chances that there's going to be a dispute down the road. Now I'll talk about valuation a little bit. Tom, obviously one of the best guys in the state board, he touched on it. In the operating agreement, I like to address evaluation concepts as much as possible. There are two really ways to do it. One is you see what's called a certificate of value, which I'm not a big fan of, and I'll explain the reason why, which basically the parties agree in the agreement what they think it's worth. And they attach it as an exhibit, and there it is. So we have a case that just started right now where it has certificate of value, and we did draft it. And it says the management committee shall establish the value every year. And that was signed in 2015. So the response is, okay, what happens if you didn't do it? It says shall establish a value, which implies that there's an obligation that the management committee should create a value. So what I'd say in that situation, we're going to use certificate of value. Also add in language that says if for some reason we miss a year, then the previous year's controls. So that's an example of, if you're going to draft for it, make sure you draft for it properly. And the other is fair market value. You can put all the mechanisms you want in the agreement. You can decide on who the appraiser is going to be in the beginning. We have the traditional, one side gets theirs, the other gets theirs, they'll do an average. There's a variety of things you can do, but again, as much as you can establish fair value of what the interest is worth, that helps streamline things. And then the last point I want to address is dispute resolution clauses, which I think are extremely important in the agreement. A lot of times, lawyers just throw them in there and just figure it out, but I'm a huge fan in operating agreements of having 3 layers of resolution. The first is the parties have to try and figure it out themselves. If they can't do it, then they go to a mandatory mediation. And then if they can't figure it out from there, I'm a fan of arbitration. No disrespect to the bench, but the reason I like arbitration is it's expensive. And because it's expensive, that makes the parties reconsider whether they want to pay, $300,000 to $400,000 in arbitrator fees to litigate this if you have a 3-person panel. So, and again, I'm very happy that the business courts, I think, pretty general throughout the state, have instituted pretty early facilitation process, which I think really streamlines the case. Because at the end of the day, it's about the money. If someone says it's not about the money, they're lying, because it's always about the money. If you can make it prohibitive for both sides, the chance of getting it resolved. So, that's all I have. Thank you. Have to answer any questions.
So we're into the final segment tonight. Judge Popke on the business court of the 3rd Circuit, Wayne County Circuit Court. Judge Popke will have a few remarks, and I have some questions that have been submitted, but if anybody wants to ask a question or make a thought or observation, feel free to do so.
So we're really lucky now we have these business courts. When I started practicing law, we didn't have business courts, and those of us lawyers, some of whom are in the room, that practice business law just dream about having a business court. Wouldn't that be great if we had judges who had a clue as to what we were talking about instead of staring at us blankly? So now we have it, so it's a dream come true, right? But on the other hand, I think you need, now that you have a business court, and many of us that sit on the business court have a background in business law, at least that was the hope and the intent. But you still, I believe, need to take David Hansma's advice and I wrote it down, know the law better than anyone else in the courtroom, because you need to have a strategy in place for presenting your case to the court, just as much as you have this strategy that you've been talking about all evening long in terms of drafting the documents and following the documents and avoiding oppression cases and prosecuting them and defending them. Now you're in front of a judge, and this judge, no matter how many seminars we go to, we are never going to know what you know. And so the things that impress us the most are the lawyers who know the law better than we do, and come in prepared and know what they're talking about and write extraordinary briefs that outline the law. And don't assume that we know what you're talking about. You'll find out pretty quickly if the judge is on top of the law that you're presenting. So, for example, in Wayne County, in all the counties, I believe, because I think it's required, we have a status conference, which is 91 days after the case is filed. So when you come into that status conference, this is your opportunity to get a leg up on your opponents, because in my courtroom anyway, I want you to come in with a discovery plan, and I know that in Oakland County they do, and every court would welcome a discovery plan. And if you come into the courtroom with a plan as to what you want to do, you can build into your plan all of the strategies that are going to help you prevail for your client. For example, I wouldn't encourage, it happens sometimes, it happens a lot, but on the TRO, run in and get the TRO. Most of the time you're not going to get a TRO. I mean, Frank's right. You're not going to get a TRO right out the door. You're not probably going to get a receiver, right off the bat. So you need to work that into your strategy. Get the court educated a little bit, and then bring up, I think Frank was talking about some of the things he's seen, like, 4 versions of the books of the corporation, or, things that are going to make the judge say, whoa, maybe we do need a receiver here. Because our initial reaction, especially in any type of business litigation, is going to be, this is money damages, because I think we ended with that comment. Anybody who says it's not money is wrong, because it's all about the money. So if it's all about the money, you're already starting behind the 8 ball in trying to get a receiver appointed or trying to get a TRO. And you want to convince the court that there's something much bigger going on. So when you come in on that status conference in the beginning of the case, have a plan before you walk in. This rarely happens with business lawyers, but the worst thing that you can do is come in. I'm standing in for Mark, and I really don't know anything about the case. I said, well, where are the documents? Do you have documents? Is there an operating agreement? Judge, I'm not really sure yet. Or, it's a non-compete case, which I know isn't what we were talking about, but where is the non-compete agreement? So when you show up in that courtroom on day 1, you're prepared, you've thought about your case, you know the law, you have a strategy, and you can also build into that strategy, when do you want some dispositive motions heard? Do you think you have a dispositive motion on whether or not there was oppression, so that you can get things kicked out right away? You can build that into your strategy to say, well, we need, Judge, we need to address these particular issues first, and then I'll be ready for a dispositive motion on a particular issue that will help narrow this case. Judges love anything that helps to narrow the case. So I want you all to be as strategic about how you approach us as you are about your cases. I wanted to tell you also in Wayne County, I mean, someone was mentioning about the decisions that are out there. And there's 3 business court judges in Wayne County. There's 2 in Macomb, 2 in Oakland, and God love Chris Yates hanging out there in Kent County. But Chris has published a ton of cases, as I know he tells everyone that he's done. We don't get to publish as many cases in Wayne County because we don't have the resources. We don't have We're not all, I know this is being recorded, so if Chris sees it, I love you, Chris, but we're not all freaks like Chris that have nothing to do but write opinions all day long and all night long, and this is what we live for. But it's hard to get those opinions out, so we don't have as many opinions in Wayne County. We also carry a half docket of general civil cases as well. So we're more limited. So the more prepared you are, the more strategic you are when you show up, the better off you're going to being able to represent your client. On the docket, there was a lot of discussion tonight about documents. And I was talking about make sure you bring them in. But I think it would be really, I spoke on a panel with Chris Yates and Jim Alexander at the beginning of the month. And one of the things that we thought was a good tip, the corporate lawyers need to be talking to the litigators when they're drafting. The litigators need to be talking to the corporate lawyers if you have that opportunity. I know many of you aren't hired until after the fact, but if you have the opportunity, so that you can help each other get those documents so that they present well in court. The part about not letting clients be cheap is I don't know how you convince them. A lot of lawyers wouldn't be working if the clients weren't so cheap because we have no operating agreements. They come in before me, they have no documents whatsoever except, we think brother A owns 60%, brother B owns 40%, and they don't like each other anymore, so now we have to figure out what to do. We are big in the Wayne County Business Court with early facilitation and mediation. So when you come into that status conference, be thinking about who's going to be the best person to get their hands around this case initially. Maybe not we, but I like to tell the lawyers when they come in on that status conference, take your litigation hat off and put your business hat on. What can we do to try and get this matter resolved for your clients without 5,000 interrogatories and document requests and depositions? And let's see if we can't narrow those issues down to what might help you get your case resolved early on. What other comments? On the valuation experts. Valuation experts, as you know, Tom, are very difficult for the court because you're exactly right. You get these three different approaches that are presented to you. Typically one side's approach is at one extreme and the other side's approach is at the other extreme. And again, it's about educating us and telling the court tell me why is the approach that you're presenting the better approach? Point out the flaws in the opposite approach, and that's what will get your judge's attention if they understand what you're doing. And just because the judge doesn't ask questions doesn't mean they understand what you're talking about. So when you make that presentation, I like the fact that under the court rules, if we like, we can have those experts in at the same time. We can have them go back to back. And I think that is a tool that the lawyers ought to think about, because if you have those experts back to back in the courtroom where the judge can ask questions or where you can point out the differences between your valuations, I think it will help you get something that is more meaningful. I think I addressed just about everybody. We were talking about, the judges have so much discretion, and what the ultimate goal at the end is in these cases is to look for fairness. So in doing so, it's so important how you present yourself to us. Are you presenting a fair approach from the beginning? Are we getting the impression that what you want for your client ultimately is something that's fair? Or are you coming in there being, the most, aggressive, over-the-top lawyer? And in these types of actions, that's not necessarily going to benefit your clients the most. But coming in with knowledge of the law, with a goal, and what you want, being fair, being respectful, all of that, and having a strategy, I think will help the court. Does anybody have questions, though, specifically on how we address different issues? We don't see as much. You might be surprised. And I talked to Judge Ewell. So I told Mark at the beginning, I'm not sure anyone will admit this, but because the venue provisions are somewhat broad and flexible, there seems to be, some sense that the lawyers are trying to get the venue to fit the particular courts that they want to be in. And so I know that might be an issue, but we don't have that many cases in Wayne. I mean, I did the CompuWare, which wasn't a shareholder oppression, but the CompuWare class action lawsuit, and but most of the ones we get are smaller ones. But what have you got, Mark?
Do you have any thoughts on early facilitation versus facilitation after discovery or later in the case?
Well, as I said, I think early, as most judges do, think early facilitation is the best. But it has to be the best for your case. Some cases don't warrant it early because the parties just need too much, which is why I try to, my question is, every time someone comes in, what discovery do you need in order to go to early facilitation? Tell me what you need so that we can send you to someone. And also, please come armed with the names of who you want your facilitators to be, because that's also an important strategic tool for you to have if you think somebody will do a good job. On the receivers, I did want to mention, for the receivers, it's a little bit of a burr in the side of the judiciary that the court rule and the statute took away our discretion as far as who is a receiver. And we no longer get to choose our own receivers, although they are supposed to be the receivers of the court. So if you have a receiver that you want to present to the court, making sure that the court is constantly aware that this is the court's receiver, that ultimately the court the person is supposed to be responsible for the court. I was just at a business court judges meeting in Lansing today at lunch with Justice McCormick. She is the business court liaison on the Supreme Court, if anyone wasn't aware of that. And there was a little bit of discussion about receivers and the fact that we no longer have the discretion to select our own receivers, and this feeling like we aren't part of that game, although it's supposedly our receiver. What else do you have? Mr. Miller?
I just have one comment on mediators, which I found to be really effective. Is when we have a mediator, it's not one and done.
Right.
If it doesn't settle that day, I think it's great when the mediator calls both parties within 30 days, then again within 30 days, and then around 90 days, have another session.
I think that's a great idea. It all depends on the case, and like I said, if we build it in, what I usually do is we structure out this early mediation. Sometimes the lawyers aren't entirely sure how successful or unsuccessful it's going to be. Of course, it depends on the size of the case, but I bring them back, the lawyers back, right after that mediation or facilitation. How did this work out? And we need to go back. And so we can build that whole process into the whole structure of the case. And we can be as creative as you are. For example, in Wayne County, case evaluation is required for any cases that have money damage. But how you do case evaluation can be as creative as you want it to be. So this mediator that you just mentioned, Powell, this person can become, if you select it properly, a really useful component in your entire case. This person may be a continuous mediator. You may stipulate to have this person be your case evaluator. or somehow, you know, to put a number, a kind of a more official number on the case, that person could end up being your arbitrator. I know there are, you know, pros and cons to whether you want to use the same person for arbitration and facilitation. They could also become your discovery master if you have discovery disputes that you need discuss during the court of your case. So there are a lot of uses for that discovery mediator and constantly going back. We are often up against our time constraints though. So if we drag the case out too long by, oh, Judge, we just need 30 more, then we can't keep our case under control, and for case management purposes, we have all of these deadlines that we have to do in the court. And again, with the receivers, Frank, there was a question about the never-ending receivership, and that is an issue for the court. And so when you do have a receivership, you have to build in the end of the case at some point in time. And again, with receiverships, another great tool for receivers is having a receiver who can identify for the court breaches of fiduciary duty claims that actually may need to be brought. And then that is a very valuable aspect of receivership that I know I like to see. If you can tell me there are fiduciary duty breaches going on out there, I want to know about that. And a receiver's that's a good person to take those on. Yes.
Judge, there's often times where you have cases where there's no operating agreement, there's no buy-sell, you have 50-50 partners.
Don't we have one? You and me right now?
Yeah, we do. It's not going to be that pointed. And you have a situation where you think the lawyers are making up arguments that there's acts of oppression, but if you really look at them, they're petty business issues.
Right.
And it doesn't really reach that threshold. My question is, does the court have a deference in those situations if you go through mediation, if you try to do everything, that at some point you have to split them up and you would actually force a sale or force a buyout between the two, even though you might not find that there's a fight, because there's going to be a claim and then a counterclaim, and everybody's going to say that they're oppressed and everybody wants to buy the other person out at fair market value. I mean, does the court have a deference to say, well, you know what, in this instance, we're going to force you guys to buy each other out?
I think that is more maybe of a good settlement tool, because it's within our discretion, of course, but then we have to find that the oppressive conduct existed. But if we're talking settlement, come on, guys, let's get this resolved. One of my quivers is to order the sale of the company and liquidate it completely, although that's an extraordinary remedy. But if somebody pushes me on the legal issue, obviously I have to rule on the legal issue, but I think it's a good settlement tool. The vast discretion that we have, I think, plays well at settlement time.
I was going to ask that if a business case, it doesn't settle in the beginning and the parties go through discovery, are there any techniques that you found after the parties have been through discovery, and a lot of times they are even further apart, or new hostilities have arisen, that after that are effective ways of resolving a case other than just the parties exhausting their resources?
Well, I think the early facilitation is a great tool for lawyers to tell their clients, this is your opportunity to get out of this case at the least amount of expense and time. And if you don't, and I have to litigate this, it'll get totally out of control and could be cost prohibitive. But I will continue to work with the parties, bring them in, and try and I'm not good at talking to the clients. I will be honest about that. And that's because ultimately I might be deciding their case. So I don't want to have I don't want the client sitting in front of me telling them for settlement purposes, you ought to be doing A, B, and C, but then I end up being the trier, the ultimate trier of fact, or I'm ruling on the dispositive motion. So it's not really conducive to meeting with your clients, but recalcitrant clients, the best thing to do is to find the right mediator or facilitator at every point, including the end. And I always try to match up personalities, backgrounds, locations, who's going to be the right person that's going to get these people to settle. Sometimes the only thing that makes them settle is a trial, dispositive motions. Sometimes we just got to call the balls and strikes, and they lose. And you can maybe your judge can help telegraph the strength of the defenses so that you can help your client see what's the best resolution. Yeah.
So, drawing on the various speakers' comments today, you see a proliferation of shareholder disputes, and yet there is inconsistency even at the court of appellate level with what is oppression. One of the virtues I thought business courts would help create, for value they would add, is consistency. What is the Wayne County Circuit Court's business court doing, if anything, to have kind of a unified approach to say shareholder disputes? What is oppression? Because one judge's oppression is another judge's business judgment. Is there any effort to do that, or is it more just on a judge-by-judge basis?
And sadly, I think it's more on a judge-by-judge basis. And we do have meetings and we do talk about issues, but ultimately different judges are going to view the law differently, and there's not that much that we can do to prevent that. It's been a problem in the history of time with the judiciary, I think. But we do, the good part about having business courts is we have annual business conferences. We have the MJI, which is the Michigan Judicial Institute, puts on business court conferences for us. Topics can be selected, and you can even call them up and say, there's a little bit too much inconsistency, I think, in how oppression is being defined by the courts. Maybe you might like to have that as a topic, because when we go to those conferences, we're all in the same room, and we have presenters who maybe you could even volunteer to be a presenter on that topic. But that's about the only way is through education, I think. Anybody else? Okay, I think I'm the only person between them and your orders out there.
All right, thank you very much, Judge. And thank you to everyone who came here tonight. I think it was very informative. If anybody has any follow-up questions or if you didn't get the materials, feel free to send me an email. If you need to talk to me about anything in that regard afterwards, feel free to come up and do so. And thank you again for coming out in the rain, and hope to see you again next year.